Welcome back to the TuckerAllen podcast. I'm Scott Trout, and I'm going to be your moderator today as we continue to bring you issues specific to estate planning, wills and trusts, and elder law. Each week, we'll bring you an attorney from TuckerAllen to join us to try to educate us a little bit on those issues that I know and the questions that you have, the questions I have as it relates to estate planning. As I always begin a podcast, and that is make sure you understand this is not an attorney-client relationship. We don't intend it to be, we don't want it to be, and it isn't advice either. This is really educational and informational. We want you to take some notes, write some questions down. I know you have them, I have them, and we want you to go seek counsel of someone who practices exclusively in estate planning like we do at TuckerAllen. You can find us on the web at TuckerAllen.com. You can call us at 314-335-1100. You can also schedule a consultation online. We're available to do that virtually via telephone, via Zoom like this, or you can come in where appropriate and where possible, keeping health and safety in mind. Today, we're joined by Teresa Yao in the St. Louis TuckerAllen office. Welcome.
Hi, Scott.
Hey, good to see you.
You too.
So, specific issues in estate planning, it's kind of what we've been talking about in the last few podcasts and just kind of breaking it down broadly so that people who hear these things, they get an idea of what it is so that they're not, afraid of it, that they understand kind of generally what that means. And so let's kind of talk a little bit about that, particularly the words that today I've heard: survivorship interests. I mean, I know that estate planning is filled with these lofty legal terms that, have to be intended to confuse the layperson, because I'm a lawyer and they confuse me. So what is survivorship interests for people out there? Just break it down for them.
Right, exactly. Well, just to break down the term, it really is just interest in property that somebody would get simply by being the survivor of the decedent, the person who passed away.
So that's their interest in the property that they may have, and that's what it's referring to?
Yeah, and a lot of times this term is brought up more in the probate avoidant conversations because people bring up survivorship interests with the aim of trying to, being a survivor, then they can avoid the probate process.
Which we talked about in our previous podcast, the importance of not, and we'll talk a little bit even more today. I know I have some questions that we've kind of carrying over by how you title things and putting a spouse or a relative on it. We'll talk about that in a minute. There's something called incident of survivorship. What is that?
So the incident of survivorship it moves us more into that legal world other than just talking about, oh, I'm the survivor of this person. It means I'm the survivor of this person, and incidentally, from the co-ownership of, like the co-ownership relationship that I have with this person who passed away, that incident of survivorship gives me these interests, legally speaking.
So why should I be concerned about, let's just talk about survivorship interests and incident of survivorship. If I'm here watching, I don't have a will, I don't have a trust, I think I've got it taken care of, but why should I be concerned about those two things we just talked about?
So exactly. So we care about the incident of survivorship because it's contingent on the relationship in which you jointly own a property, right? In Missouri, there's really three main ways of co-owning a property. And depending on that type of co-ownership relationship, there either arises an incident of survivorship or not, and kind of what are the consequences of that.
That's a great segue. And we talked about in the last podcast about kind of co-ownership of property. Let's just take it as a vehicle. So walk me through the different types. I know you've got kind of a spouse, a relative, or a friend. What are the types that I know people that are watching right now have done already? They've probably heard from their neighbor or their friend, hey, this is the way to avoid it. But let's walk them through those types of co-ownership in Missouri.
Absolutely. So this is where I'm going to get a little legal jargony, but I'll try my best to break it down. The first type that we think about is tenants in common. And really, this is a type of co-ownership where each person that's an owner owns their share of the property separately, individually. What that means is they can pass on their share of the property to whoever they want, to their heirs or to whoever they designate. So they each own those interests separately rather than each owner owning like whole control of the property. This is a very common setup if it's not like a familial relationship or a spousal relationship. The downside to tenants in common is that it still retains the creditor liability of your co-owners as well. And then the second type of ownership is joint tenants with right of survivorship. So this is the one where the incident of survivorship kind of comes into play. And what this means is together, you and this co-owner own this property entirely, right? And then if one of the owners passes away, then the surviving owner gets the property in sole possession. However, under this type of ownership, it still exposes the owners to each other's liability. So there's still no creditor protection, very much like in the tenants in common. And then so that brings us to the third type of co-ownership in Missouri, which is called tenancy by the entirety. And this is solely reserved for married couples. And it essentially retains all the benefits of the tenancy by right of survivorship by having the incident of survivorship, where if you own it together as husband and wife, if one of you passes away, the surviving spouse gets that home and retains the control of that home. And the benefit of this one is that the creditor of each owner creditors of each owner does not actually access that joint property. So,
I think that you think about individuals who don't have a will or a trust, and they acquire, let's just say, a house, a vacation home, and they title it with one of their children. And they, in their mind, because they've added their child to the title, they think they're covered from an estate plan purpose, that they're avoiding court, and if they were to die and they have no husband or spouse, it goes to their child without court intervention. Is that true, or is that not necessarily true?
Yes and no. So a lot of people do that, right? A lot of people are like, oh, well, let me just purchase this property with my son, and that way it'll just go to my son after I pass away. We own a right of survivorship. Mm-hmm. Great, in that you might be avoiding probate, but in the meantime, you're also exposing yourself to the liabilities and the creditors of your co-owner. And a lot of times people don't even think about it from that angle when they take this step.
Right. I mean, I think that's what I hear and what I see a lot of people do. They just start titling things, and they are convinced that's the appropriate way to do it. And I think that's kind of the caution that I wanted to get through today, is that great first step, but it's kind of like starting a race and you've only finished halfway, and that's it. And you stop. There's no point. You wanted to finish the race. You just chose not to.
We had a lot of conversations on what would happen if we weren't here, and I don't know. TuckerAllen was super convenient. It was so easy to go through and get the package that we needed.
The website was simple, easy to use. You could schedule a time to actually meet with somebody.
It's one set fee for a will, one set fee for a trust.
It's our wishes in place. It's everything we want for our daughter.
So I think that's kind of the moral of the story, is finish the race, go get some advice from someone who does this, and let's look at your assets and let's determine whether or not what you've done is appropriate to accomplish your goals. Avoiding creditors, avoiding taxes, avoiding probate, avoiding anything with court intervention. So I think that's kind of we talk about the titling. It's so prevalent. I mean, people constantly, every day, I see them taking their own steps.
It's
right.
also like bank accounts, financial accounts, for all different types of assets.
Right. Cars, homes, boats, trailers, checking accounts, investment accounts. Everybody has been told for years, oh, yeah, just go retitle it with someone. You're good. And I think that what you're saying is not necessarily right.
Right, exactly. And I think in terms of meeting the aims of being probate avoidant and actually wanting to preserve these assets for your descendants or your beneficiaries, you can do that. You don't have to do it through the joint account, right? You can set up beneficiary designations on your home, on your assets, on bank accounts or financial accounts. Those are payable on debts. And with homes, we have beneficiary deeds. So you can still achieve the same aim of avoiding probate and then passing it on to loved ones without really taking on that creditor liability of co-owners.
You just mentioned payable on death, POD. What's the difference? So I guess look at a joint account versus a payable on death. What's the difference? Because I know a lot of people, when they open a bank account, that's an option on the signature card where you see, either transfer on death, payable on death, something like that.
Yeah, so kind of similar to what we were just talking about with homes, it's like equivalent with a bank account. With a joint account, when you create a joint account with another person, that means any of the money in that account is open to the liability to the creditors of that co-owner, right? And then the payable on death is that alternative where you are the sole owner while you're alive, but then the beneficiaries that you designate as payable on death means after you pass away, these assets in the account can swiftly pass to your beneficiary. So the payable on death beneficiary can just come in with a certificate of death and say, hey, I'm the beneficiary on mom's account, and then attain that asset.
And no will necessary so long as it's designated appropriately.
Yes.
So what is, let's say my wife and I are traveling and, God forbid, we both die in an accident. What happens?
So in simultaneous death in Missouri, we follow both the Uniform Probate Code and the Uniform Simultaneous Death Act. And what that means, under the Uniform Probate Code, there's a 120-hour rule. So that's saying if there is a survivor, they have to survive the decedent by 120 hours in order for them to actually inherit from that person. In the case of simultaneous death, where really it's very hard to tell who survived the other, then Missouri treats it in a way where each other survived the other person. So that's how that works.
And so what if I'm, listening and watching, what impact does that have on me in terms of, should I be planning? If I die without a will and there's simultaneous death, what's the difference between actually taking steps to plan versus doing nothing and having that happen?
So when you take the steps to create an estate plan, you can designate saying, hey, if this happens to me, and then here's the people that I want to designate and who I want to receive as the beneficiaries, right? And then if you don't have that plan, it gets a lot murkier, and that you have to refer to the Missouri statutory succession rules about who can actually take from your estate. So
you could eventually say, in the event of our simultaneous death, my wife shall be treated as surviving me, no matter what.
Yes,
and,
exactly.
And that would allow for a smoother transition of the assets without probate if you did it accordingly and correctly.
Yeah, and you can also put in a more specific survivorship term saying, hey, I want this person to survive 30 days after my death in order for them to take, just in terms of swifter administration of those assets, if you want to make that survivorship period a bit longer.
As I listen and we do these podcasts and with some of the other attorneys, it can be so complicated with some of the things that I don't even think about. And as we think about planning, I think about my health, and do I get sick? I don't think about a simultaneous death. I don't think about a disaster like that or whatever were to happen, because it can be so complicated when you don't think and plan. It's like we've been ingrained to plan for our retirement. Save some, put some in a retirement account, do this, watch how much Social Security is going to provide you. Don't, have so many debts. You plan for it. Or it's like putting money away for a vacation, but yet we haven't been educated enough to start planning for ultimately the thing that we don't want to talk about, and that is our death, right? But there's so many potential pitfalls. Like we just said, simultaneous death, it just begs for someone to call you and have a plan, right?
Right, exactly. I mean, it's always more assuring and easier to plan around certainties in life. Certainly I'll retire at some point, but it's a lot more daunting to wrap your mind around planning around uncertainties, but it is important to do nonetheless.
You hear of surviving spouse. What are the rights of a surviving spouse? And we can also talk about divorced persons too. What, how does that impact estate?
Yeah. So about surviving spouses, I'm talking more in the context of, in the event if people are separated, but they're not divorced, and this spouse, they're technically still married, But people, because of the separation, want to disinherit this spouse. What are the rights of the surviving spouse still? So in Missouri, the spouse has an elective share, so they can technically elect against the will. And what that means is they are still entitled to a certain amount of this person's estate. Under Missouri law, if the surviving spouse and the decedent, if they don't have any descendants, then the surviving spouse is entitled to half of the decedent's estate. If there are descendants, then the surviving spouse is entitled to a third of that decedent's estate. As for divorced spouses, if the divorce is finalized and everything, and let's say you created an estate plan with your spouse in the past, if after the divorce, technically your spouse is assumed to have predeceased you. So that means in your estate plan, their role as beneficiary, their role as fiduciary, they're kind of technically erased from that. Some people who have amicable divorces might still want to have their ex-spouse to be, listed as one of their confidants as a fiduciary. So in that event, you'd have to update your estate plan to kind of restate those terms too.
So particularly if you designated your former spouse as the personal representative, but didn't designate anyone else, does that create a problem, or what happens in that regard?
If you in your will designate your former spouse so you would just want to redo it so that your spouse can still act in that role. And I kind of think of that as two separate things, right? Then we just look at their will and just making sure that they have it set up on who they want as their personal representatives.
Yeah, and I think it's cleaner as I'm thinking through it to, if you do get divorced, don't just rely on this, the divorce spouse provision that says, she predeceases or he predeceases you. It's just cleaner, just make some amendments, right, to your will, or create a new one, or make some amendments to the existing will, right?
Right, and actually this touches on one of the pillars of estate planning. After you create an estate plan, it's important to revisit it, like every few years at least, but especially at these like major life changes, you would want to revisit it, so.
Yeah, and even as you acquire more assets, obviously as you're doing it younger and healthier, things change, and it's always good to just revisit it, because people may be watching right now that say, I've got an estate plan, I don't need to worry about any of it. I'd encourage them, it's worth the 30 to 60-minute visit just to make sure everything's covered. Probably the best investment of your money, especially when we're talking about if perhaps something went wrong with the execution of the will. It's not valid. Now you could be paying 5% of your estate value to an attorney. Who wants to pay an attorney, right? More than they need to.
Right.
So, Teresa, great stuff. Thanks for joining today and kind of filling people in on those lofty terms that no one understands, and we're trying to break down estate planning. So thanks for joining.
Well, thanks for having me.
Well, continue to tune in. You can find this information obviously on our web at TuckerAllen.com. You'll find these videos and more like it as we talk about estate planning, wills, trusts, elder law. Continue to tune in, and we'll continue to bring you the attorneys at TuckerAllen to provide you with the latest information. Reach out to us at 314-335-1100 if you have questions, you want to schedule a consultation, or again, visit us at the web, TuckerAllen.com. Until next time, have a great week.